My name is Andrew Campanelli. I've been a litigator for roughly 32 years. I handle cases under among other things, under the Federal Telecommunications Act of 1996, cases involving claims of violations of the Telecommunications Act of 1996, prosecuting and defending, things like that. For decades, I've had local governments employ their powers under the Telecommunications Act to prevent the irresponsible placement of wireless facilities within their respective jurisdictions. Again, I've litigated cases, and that's pretty much it. I also draft local zoning ordinances for local governments who want local zoning ordinances which vest them with the maximum power preserved to them by Congress under the Telecommunications Act, and ensure that when they decide applications for wireless facilities, they do so in a manner that does not violate the federal act. I've been asked if Act 50 of Pennsylvania is the gold standard for the regulation of small wireless facilities in public rights of way. I guess the best way I would describe Act 50 is that it is a hoodwink ordinance. It's not the worst hoodwink ordinance I've seen, but it's pretty bad. Hoodwink ordinances are ordinances which are the product of deception, where a state legislature has been misled or deceived or tricked by perhaps representatives of the wireless industry to enact legislation which strips from local governments far more regulating power than the state intended. And Act 50 is such an act. When you want to look and see if a state act is a hoodwink ordinance, you look for some of the basic red flags. Those red flags are terminology, things like small wireless deployment, right-of-way, co-location, and wireless support structure are the four key terms which are used to mislead local governments and state governments, and Act 50 is one of those. So, for example, Act 50 talks about regulating small wireless facility in the public rights of way, and presumably it was presented to the General Assembly of Pennsylvania as, oh, this is just talking about little wireless facilities going on existing utility poles, and they're all physically small in size. Well, Act 50 doesn't do that. In fact, Act 50 purports to give site developers the power to put wireless facilities on people's front lawns. Because when you start with the definition of right-of-way, right-of-way is used to include the term utility easements. And to the extent that anybody has electric in their house, they have a utility easement. 11 years ago was the first time I encountered a case where a site developer put a cell tower 30 feet into someone's front lawn. And the basis of the authority to do so was there was a utility easement. So although the Assembly probably didn't intend to adopt a law which empowered site developers to put cell towers on people's front lawns, that's what they did. And across the nation in the 5G rollout, we're seeing cell towers showing up on front lawns, on side lawns, 5 feet from someone's bedroom, and it's precisely because of laws like Act 50. In similar vein, they make it sound like it's only co-location on existing utility poles when nothing could be further from the truth. First of all, Act 50 has nothing to do with co-location. In hoodwink laws, they take the term co-location and they pervert it. They include the term and then they include a definition to cause the term to mean the opposite of what it means. Co-location of a wireless facility is very straightforward. It means there's an existing wireless facility and you simply add more transmitters or equipment onto the existing facility. That's what co-location actually means in the context of zoning, for zoning approvals for wireless facilities. In hoodwink laws like Act 50, it means the opposite. Co-location doesn't mean co-location putting new equipment on existing facility. It means putting it on anything that can hold it up, whether it exists or not. It's not limited to public rights of way. It's not limited to main roads or side streets or things like that. They can go on any utility easement. And this will enable a sophisticated site development company to pretty much put them up any they want. They can put them on people's private property and the homeowners can't stop them. So Act 50 is a hoodwink ordinance. It's not by far the worst. There are many worse ones than this, but this one's pretty bad as well. So if any state representative says this is a gold standard, then they don't know what they're talking about. Now, one of the biggest farces that I hear all the time, and unfortunately, very often it comes from attorneys representing local governments, is that your hands are tied by the Telecommunications Act. There's nothing you can do. You can't regulate these things. That is as false as a statement can be. The fact is, when Congress enacted the Telecommunications Act of 1996, the very first thing it did is to preserve to state and local governments the general authority to regulate the siting, placement, construction, maintenance, and operation of wireless facilities, C7A, which is entitled General Authority. And within that section, Congress explicitly preserved to local governments the general authority to regulate the placement of wireless facilities. The only reason local governments don't exercise that power to the full extent preserved to them by Congress is, number one, they don't know it exists, or two, even if they figure out it exists, they don't know how to use it. They don't know how to do, or you don't use it in a way that complies with the procedural requirements imposed upon them by paragraph C7B and its subparagraphs. A perfect example is a proposed ordinance for the township of Lancaster. Apparently, Lancaster is looking to adopt an ordinance setting standards for the placement of small wireless facility in rights of way in Lancaster, Pennsylvania. This ordinance, as drafted, if it gets adopted, it will essentially empower any site developer to pretty much put up a cell tower or wireless facility anywhere they want, including on private property, and the town will be incapable of stopping them. In fact, if the town ever denies an application, they get sued in federal court and they lose every time because of the gaps in this law. So, local governments have broad power to regulate the placement of wireless facilities, provided they draft a code, which, number one, lets them take hold of the power that Congress preserved to them and make sure that when they exercise that power, they do it in a way that complies with the procedural requirements of the Telecommunications Act. That's it. The problem is, with laws like this, the boards don't know what factual determinations they're required to make to comply with federal law. And that's why this ordinance, for example, I would never adopt this ordinance. I would never suggest anyone adopt this ordinance. So that's the long and short of it. The question of hands being tied, total farce, completely untrue. Lawsuit intimidation. A lot of times I hear, we're afraid. God, what if we turn them down? We'll get sued in federal court. They'll bankrupt the town. That is a complete red herring. It's complete nonsense, and here's why. According to the United States Supreme Court, if a local government denies an application, gets sued in federal court for allegedly violating the Telecommunications Act, and they win, if they win a claim under the TCA that it was violated, they don't get compensatory damages and they don't get attorney's fees. So the municipality, generally speaking, pays them not one red cent. If a local government adopts something like this, you are throwing your planning board or your ZBA to the wolves. You're asking them to do a task which is impossible because you haven't given them the tools they need to complete the task.